Hello there and welcome to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru. We talk about your workplace rights, your severance, your boss. Maybe you are the boss. Lots of stuff to cover every week. If you have not caught the show before, well, welcome. And you're about to be educated big time. 1-855-821-5900 is the phone call anytime you want to make it. And we'll get to some emails and some phone calls from a radio show as well. We'll play those back in the air. Lots of stuff to get to today, including the severance pay calculator. But first, as we always start, pal, with the week that was, what is happening in your world?
Well, John, it's a great thing to have this forum here to be able to come up on TV and talk about these things, because we reach a lot of people. We educate a lot of people. And I have people coming up to me saying, hey, I didn't know about this. Thank you for talking about these issues. So I'm so happy to hear that. So for you as well, if you haven't caught the show before, or if you have, we hope you can learn new things about your workplace rights, your employment law situation, how there are solutions. You have a lot of entitlements. The law in this province is actually tremendous when it comes to protecting individuals and protecting employee rights. But the law can't help you unless you know what it is. So that's what we're here about, to talk about those workplace problems. And if you have any problems, if there's anything you want to talk about, don't hesitate to ever reach out to me, call or email. We'll give you that contact information throughout the show today. But week there was, John, as you said, situation that came across my desk just a few days ago. I spoke with a gentleman who found himself in a bit of hot water with his employer. He'd worked for a large bank, and apparently there were some issues in terms of how you ran some of the finances, how you process some numbers and dollars. Not a good thing. Although he professed to me that he never did it, there was all a big misunderstanding, there was nothing really wrong. Well, what the bank did is they decided to put him on a suspension while they investigate, except it was an unpaid suspension.
Guilty.
Completely an unpaid suspension. And he had already, by the time he called me, had been off on a suspension, an unpaid suspension for 2 weeks, and wanted to know what's going on. They never got back to him. They hadn't responded. We're still investigating. Beyond that, nothing was said. So he called me and he wanted to know what's going on. Well, here's the thing, John. An unpaid suspension generally is illegal. An employer does not have a right to suspend you without pay. And the reason for that is they're punishing you. So an employer is essentially punishing you while they're trying to determine if you should be punished. That's nonsensical. Yeah. So no, an unpaid suspension is illegal, unlike, of course, a paid suspension. An employer generally, as long as it's being reasonable, does have a right to suspend with pay. So what happens if you've been suspended without pay? Well, you have the right to treat that as a termination. Even though your employer has not terminated your employment, they're supposedly investigating, they're supposedly determining what they should be doing with you. You can treat that as a termination and leave with severance because of the fact that an employer does not have a right to suspend you without pay. Now, if your employer suspends you without pay for a day, probably doesn't make sense to treat that as a termination. You may be able to, by the way, but probably doesn't make sense. This person had been off for 2 weeks already. So I told them, rather than sit at home and try to and be worried and freaking out as to whether or not they're going to call you back, is there going to be other punishment, you can treat your employment right now as being terminated. Enough is enough. Leave with your severance. So that's what I'm going to do with them. And I wanted our listeners and our viewers to remember that if you've been suspended without pay, for the most part, that is illegal. That is a constructive dismissal. Your employer does not have a right to do that.
In this case, like changes to the employment relationship, is there a time limit how long this guy can stay off and have deemed accepted this punishment? Like, it's 2 weeks for him. Could it be a month, or it's too late?
Once he comes back from that suspension, if he does go back, he's deemed to have accepted it, even if it's a day or two. While he's still off, he hasn't accepted it yet. But if they, after 2 weeks, 3 weeks, 6 months, whatever it is, say, okay, fine, come back, and he goes back, at that point, he's accepted it, and he's given the company the right to do it again in the future. So you don't, just like with any other changes in terms of employment, if you let it happen, you give the company the right to do it again, and the next time they do it, you may be stuck, you may not be able to proceed and treat it as a constructive dismissal. You only have one shot at it.
EmploymentHourTV.ca is the place you want to go to find where you can catch our radio show. From the radio show, we play the phone calls on this TV show. That's how it works. And we comment on them. First show of the day is right now.
I booked some time off of work. I gave them about a week and a bit's notice, and they said, yeah, it's okay, your shifts are covered, you're good to go. I went on vacation, came back. They told me I had a write-up waiting for me. The write-up said it was for not giving 2 weeks notice. I refused to sign that, returned to work like normal for another week and a half or so, and then I was taken off the schedule. They said they took me off, and they're not putting me back on until I sign the write-up. Security, between 3 and 4 years.
Wow. It's not a nice situation.
No, not a nice situation. And actually, it's a silly situation. If he had his vacation approved and he took vacation because of that approval, he has done nothing wrong.
Makes sense.
The company can't approve it and then say, well, you didn't go through the proper process of getting it approved. Well, then you shouldn't have approved it. So in this case, he's done nothing wrong. His employer cannot penalize him, and his employer cannot threaten him, and certainly he should not be signing anything. So what's happened here? He went on vacation that was approved. He came back. Now he's not getting any shifts. What is that? That is a termination. They've terminated his employment. He shouldn't be made to sign something to go back to work when he did nothing wrong in the first place to deserve being off work.
Right.
So because of that, John, he's been terminated. No matter what his employer says, that's a termination. He now can treat that as a termination, leave with his severance. So the question becomes, of course, how much severance? Well, let's plug his information into our handy severancepaycalculator.com website. Let's see on the screen right now what this person gets by way of severance. So he's a security guard, been there for about 3 years. I picked an age, let's say he's 37, sounded 37 to me. Obviously, he got paid no severance, and he's owed as much as 3 months of pay here. 3 months of pay. He did nothing wrong. His vacation was approved. He's owed that much compensation. You can check it out yourself in your situation at severancepaycalculator.com. He's owed that, John.
Again, employmenthourtv.ca to find out where you can catch our weekly radio show. For the past 7+ years, we've been doing that. Phone call number 2 is right now.
Somebody posted something anonymously, and it was extremely slanderous about me. It was saying I was rude, demanding, sexist. We decided to do an investigation on my team, and then I was given a letter that is to go on my file saying that 50 to 80% of my team believe that this is true, but that is not the case. My team supported me 100%. Now I'm asked to sign a piece of paper that says I am a sexist and a racist, which is totally not true. It feels like it's made up, and I need to know what my rights are.
I remember that call.
I remember that call as well. And listen, it's very important for an employer when they become aware that there could be a problem. Someone could be mistreating employees, even if they don't know for sure. But if they know that that's a possibility, they have to investigate. Okay, right off the bat, an employer should not ignore these issues. So if an employer found out that someone posted online that one of their managers is mistreating employees, they can't say, well, who cares? No one said anything to us. They have to investigate. But it has to be a legitimate and unbiased investigation. They can't make up things. They can't ask questions that are inappropriate. They have to conduct a proper investigation. Now, if you're the person that's being investigated, you have a right to also face your accusers. If you're being told that you're mistreating people, you need to be given particulars. Who said that? What examples did they give? Provide an opportunity to the individual to respond. You can't just be accused of things without being given the opportunity to respond, to know who said what was said, dates, times, particulars, so that you can provide a meaningful response. Now, beyond that, if you are presented with a document that doesn't reflect the truth, sign here to say that you did something wrong. If you don't feel that you did, never sign it. Because if you sign it, later on, you won't be able to say, that was wrong, I didn't agree with it.
Right.
And later on, the company may be able to rely on that document if they want to let you go for cause. So never, ever sign a document you don't agree with. Never, ever sign a document saying that you did something wrong if you didn't, if you don't agree with it. What do instead? You say so in writing. Here's what actually happened. Here's why I disagree with it. Here's why this is false. Put that in writing rather than agree with it. And if your employer won't let you come back to work, disciplines you for that, that could be a constructive dismissal. That's illegal. You cannot be penalized without given the opportunity to respond. You cannot be accused without given the opportunity to know what the accusations are. Anything less than that is inappropriate.
It's like anything else we talk about in the show. If there's any sort of conflict or you're not sure how it's going to play out in the future, always write it down. Have written records for everything.
You can never, ever go wrong with writing things down, creating a written record. And when it's time to contact me for help, I'll be so happy that you did. You'll make my life easier in helping you.
Help at employmentlawyer.ca is the email address to reach out. What we want to talk about on this show, we got it down to 5, and that is the 5 things people are still getting wrong about termination. It could be 105, but we're going to do 5 today. Because these are all very important, right? They can make a huge difference in your future.
It can make a difference in your future, in your financial well-being, in your family life, because a lot of people still today accept so much less than they're owed, tens of thousands of dollars each of them. And the reason for that is because there's misconceptions, there's things they don't know, things things that people believe to be true, whether are not true.
Right.
So we want to talk about those things here. There's some common situations, common facts that people believe are facts, which are not true. So we'll talk about that.
Number one is your employer can legally let you go for many reasons.
Probably one of the most common questions that I get in my office is, common comments, is my employer let me go, I did nothing wrong, that's wrong, they've wrongfully dismissed me. Well, no, that's not a wrongful dismissal. Your employer does have a right to let you go pretty much for any reason as long as they pay severance. So when you talk to me about your termination, the reason why I focus on your severance is because that is what the law can do. The law can't make your employer a better person or give them a better reason to let you go. The law can only make sure you get compensated by way of severance. You can be let go for any reason unless, of course, that reason is discriminatory.
Yep.
You cannot be let go because of your age, ethnicity, disability, sexual orientation. That is illegal. But beyond that, good reason or bad reason, you can be let go, but full severance has to be paid.
5 things people are still getting wrong about termination. Number 2 is that termination for cause is likely not legitimate.
You may have done something wrong. You may have even done a couple of things wrong, and you may think, okay, well, I did it. I know I did, I'm guilty, so clearly if they let me go, that's right. No, not so fast. The fact you did something wrong, or as I said, a few things wrong, does not mean your employer can let you go for cause. Cause is the death penalty. It's reserved for the worst offenders. You can only be let go for cause if what you did is so bad that it's impossible to continue employing you. And when we say most terminations for cause are not legitimate, what I mean by that is the employer pulls the trigger before it should. What the employee did was not bad enough, or the employer did not engage in other discipline, warnings, suspensions, etc. The employer jumped the gun. Most of the time, John, 9 out of 10 times, when someone comes to me with a termination for cause, in the eyes of the law, that is a without cause termination, and that individual is owed compensation. So if that happens to you, if you're let go for cause, chances are you're still owed your full severance.
Yeah, you're in a forklift and you drop a skid one time. It's not enough to be let go for cause, right?
Or 2 times, frankly, even 3 times.
Yeah.
It's probably not because cause, it's so difficult to establish the worst offenders.
5 things people still get wrong about termination. Number 3 is you should not, you can't emphasize this enough, should not go to the Ministry of Labor if you've been let go.
You know, I one time we'll do a show just on this topic, maybe several shows. It's that important. I still speak with people every single day, no exceptions, that are let go and either contact the Ministry of Labor for advice or worse, file a complaint with the Ministry of Labor because they were let go. You cannot do either of those things. Now, the Ministry of Labor can help you with your overtime issues, your vacation pay issues, your hours of work issues, no problem. They cannot, and you should not try to get them to help you with your termination entitlements. The Ministry of Labor can only advise you with respect to a small portion of your entitlements, what we call your minimum entitlements. You could be owed 10 times that, 20 times that. And unfortunately, if you call the Ministry of Labor, you ask them, how much should I get after 2 years of employment? They'll tell you 2 weeks' pay. That is wrong. You could be owed as much as 6 months' pay. So, and if you file a complaint with the Ministry of Labor, you're prevented from seeking your full entitlements. So, no matter what, as a general rule, say it to your friends as well so that they know. If you lose your job, you got to go to severancepaycalculator.com, call me, call another employment lawyer if you don't want to speak to me. But what you cannot do under any circumstances is go to the Ministry of Labor.
It's such a natural reaction to do so, though.
Yeah.
Ministry of Labor, lost my job. Ministry of Labor, that's where I should go.
And they have a 1-800 number to make it easy on you. No, despite that, despite the temptation, you cannot. Again, other things for sure, not when you lose your job.
The list of 5 things people still get wrong about termination. Number 4, severance is not based, as much as they would like it to be, severance is not based on what your employer wants to pay you.
Yeah, or thinks they should be paying you. A lot of individuals believe, well, my employer is going to pay me this, that's what they think is appropriate, or they must know better because they're the big, smart, knowledgeable employer. No, the employer doesn't decide. The employer doesn't have a say in this. The law decides that, okay? Our courts have decided that over the past 150 years, how much severance individuals have to pay. It's based on your age, your position, and the length of your employment. The reason why I have 25 lawyers now at my firm is because of the fact that employers, for the most part, 9 out of 10 times, if not more, provide a lot less than they're owed. because individuals may not know better, may think that the employer must know better, or just are under some sort of misapprehension or misconception. So now you know better because you're just watching us right now. Your employer doesn't get to decide that. The law decides. You can go to severancepaycalculator.com to find out how much you're owed. What your employer thinks or wants to do is irrelevant.
5 things people still get wrong about termination. Number 5 is right now, you do not have to sign your papers, sign your termination papers on the way out the door.
No, not only do you not have to, it would be a massive mistake to do so. Yeah. Now, there's a deadline. You'll see always in a termination letter, there's a deadline. Oh, you have to accept this by Friday at 5 o'clock or Tuesday at 2, whatever it is. And you feel the pressure. Well, I'm going to sign this because it's going to expire. Your legal rights don't expire on Friday or Tuesday or whatever the date is. They don't expire for 2 full years. Now, the reason why that's there, it's a pressure tactic. You cannot sign off on that severance offer until you know what you're owed. Because when you sign off and you realize a week later that you're owed another $50,000,
you're done.
You're done.
Yeah.
It's too late, and I can't help you. And I get calls like that every day, and it always makes it so difficult for me to say, yeah, you would have been owed another $50,000. $50,000, think about it. But I can't help you because you signed that piece of paper. And I always get the answer, well, I felt pressure, and I don't doubt it for a second. But legally, once you sign it, you're stuck with it. Please don't ever sign off on that offer until you get some advice.
Quickly, what do they do on the spot? Just say thanks, I'll take it home and chew on it for a while.
That's it. You take it home, you think about it as long as you need to. Don't worry about that deadline.
Because they're going to tell you, well, if we don't, it might not be as much when you come back. That's what you get, right?
John, I love my $100 examples.
Yeah.
If I owe you $100, and I say to you right now, John, I'll pay you $30, but you have to sign this paper or else, you're going to say, well, no, you owe me $100, pay me $100. Yeah. Well, that's how it works with the severance package. Yes, they owe you 12 months pay. They offer you 4, but you only get that 4 if you sign. That's silly. That's ridiculous. If you're owed 12 months pay, you should get 12 months pay. Not 10, not 8, not 4, nothing else.
Struggling to keep up with a new sales quota? That in the severance pay calculator. We'll dive into both those and more after we take a short break. 1-855-821-5900 and employmenthourtv.ca as well. Employment Hour 30 continues. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Hour in 30. This is the time of day where we talk about severance pay calculator at severancepaycalculator.com.
And we touched on it already in the previous segment, but it's such an important tool. We were talking about things that you need to know, or things that people believe about severance that are not true. So let's be very clear. The easiest place to find out what you're owed if you lost your job is severancepaycalculator.com. It's easy because it takes seconds, and it's accurate, and it's going to tell you the real amount. I talked before about not going to the Ministry of Labor. You can't go to the Ministry of Labor if you lost your job. Well, severancepaycalculator.com is the place to go to. You'll answer a question about your age, your position, the length of your employment. You're just going to pick it from a drop-down menu, and that's it. You're done. You'll know exactly right off the bat if what they offered you is good, is it not good, how deficient is it. Maybe you haven't lost your job, but you're worried about losing your job, or you're curious. You want to be prepared. You want to have that information. Severancepaycalculator.com. And remember, it's not a week's severance per year of service or 2 weeks of severance per year of service. It's much more than that. You don't believe me? Try it for yourself. Severancepaycalculator.com.
Again, free. You can't insert a credit card anywhere. There's also an employer mode if you're thinking about what you should be doing properly to let someone go, how much you should be paying them as far as severance is concerned, to keep up with your proper severance amount. Severancepaycalculator.com. We always run an example through Lior, and we talk about it, and you break it down. For today, 43-year-old Raoul worked in sales role for 12 years. when a local competitor began eating into the company's profits. Raoul's manager increased his sales goals. That often happens, right? He failed to meet the new quota and was let go a month later with 12-week severance pay. How much is he really owed? 12 years working there.
Yeah, well, whenever your employer kind of pushes away the goalpost and makes it more difficult for you to do your job, that is actually a constructive dismissal.
Wow.
So if I'm supposed to hit a certain target to make money, and now that target has changed, so I'm not going to be able to make that money, well, it's essentially have taken a pay cut, right? So your employer cannot just change the goals that way unilaterally unless you sign an employment agreement that gives them the power to do that. If they change your targets, change your goals, and because of that you make less money, you could be in a position to treat this as a constructive dismissal. Well, we don't even have to deal with that here because Raoul's employer flat out let him go. They're allowed to let him go. Remember, I said that before.
Yep.
But they have to pay severance. So the real question is, Raoul, after 12 years of employment, the 12 weeks pay that he was offered, is that adequate? Well, I can tell you, but let's just plug it into severancepaycalculator.com. We can see that on the screen right now. So he's in a sales role, 43 years of age, 12 years of service. And he was offered, hey, 12 weeks, a week per year. Except correctly, the severance calculator assesses him as being owed 14 to 16 months pay, months, not weeks. Now, for him, that's a $50,000 plus difference. Okay? Now, we didn't come up with this, hey, let's come up with this crazy scenario here. This is a common situation. This is something that I see every day. This may be you if you lose your job and if you don't use the severancepaycalculator.com website. That's why you have to do it.
I mean, the number there is easy because we had it on the screen, but some people in sales might be listening going, well, my sales do this. How do you calculate what my severance is, even if it is 16 months? What do we do?
So it's very simple. If you have a compensation that varies from year to year, month to month, we simply look at an average. So we look at a 1 or 2 or 3 year average, depending how long you've been there, and we use that figure. Cool. So you may have compensation that changes, but if on average you make $50,000 a year, we're going to use $50,000 in calculating your severance. It's as simple as that. Bottom line, though, very important, when it comes to your severance, your commissions have to be included, your bonus has to be included, your overtime has to be included, your car, your benefits, your pension. All components of your compensation must be included in severance.
EmploymentHourTV.ca, the place to go to find the radio show that we do every week. Another phone call number 3 from that show is right here, right now.
I was working for this company and I got laid off. I was like there 6 years, senior, There were other younger, unqualified guys that came in like a year or 2 before, trying to get rid of senior employees because they don't want to pay the seniors more.
Yeah. Over the old in with the new, pay them less.
Well, I said earlier in the show, John, that an employer can let you go for any reason so long as they're not discriminating. Right. Well, this could be one of those situations. If your employer is discriminating against you because of your age, if it's age-related, then that's illegal. You cannot be let go because of your age. It's as simple as that. So an employer may think, well, we'll bring younger employees and they'll work harder. Maybe we can pay them less. Well, whatever the reason is, whether they think it's a good one or a bad one, it's illegal. They cannot do that because of age. Now, if they say, well, this person has worked there for 20 years, we can bring someone with less experience and pay them less, that's fine, as long as it's not age-related. So we don't need a 20-year employee. We can have a 1-year employee because it's a simple job. Again, age, illegal, experience may be illegal. So the devil's in the detail, but the lesson is very important. We have an aging workforce right now. If you're one of these individuals, you're in your 60s maybe, you still want to work, you're working, and your employer says, no, we don't want you here, or we're going to bring a newer blood. If you're let go in any way, or your job changes in any way because of your age, that is illegal. That cannot happen. We have human rights laws in this province, and if an employer does that, they're going to find themselves in some very hot water very quickly. Not only would that be a wrongful dismissal, that would be a human rights violation. If that happens, definitely reach out to me.
And a quick side note, there is no mandatory retirement anymore. It's for about
gone.
12
It's been
years,
gone for many, many years, 12, 13 years now. At least if your employer says to you that you have to retire at 65, your answer is going to be no, thank you. There's no such thing as mandatory retirement. You can work as long as you want to.
Denied LTD and forced back to work. We'll deal with that after a short break. You want to reach out, 1-855-821-5900. Employment Hour in 30 continues. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Right to it. Employment Hour in 30. Phone call number 4. You want to go to employmenthour.ca, employmenthourtv.ca to find where you can catch a radio show from where we get these phone calls from. Number 4 for the day is coming up right now.
I was working for a company about 6 months ago. There was a new president that was brought on. Shortly thereafter, he brought in some new VPs. So I, at a director level, got a new boss that I reported to. About a week before Christmas, me and my whole team were let go. I had signed an agreement about 3 years ago when I started with full-time with the company. Unfortunately, in it, I signed that it would be 1 week per every year that I worked there for severance.
Right before Christmas.
What a
Nice.
classy,
Yeah.
very, very classy. Well, we talk often about on this show and our other shows how much severance employers have to pay. Well, employers starting to realize, holy cow, we got to pay a lot of severance to these employees. So one of the ways employers are trying to reduce those obligations is by having employees sign employment agreements that limit their future severance. Now, an employer can generally do that, but here's the good news. The good news is in many cases, I'm going to say 75, 80% or even more of these cases, the employment agreement, even though it may try to limit your entitlements, doesn't do that effectively. So it doesn't actually limit your entitlements. So chances are, if you sign an employment agreement that you believe or even the company believes limits your entitlements, that term in that contract may be unenforceable, which means you are owed severance. Now, going back to this call that we just heard, if this person, in fact, after 3 years got 3 weeks' pay, if he had an enforceable term that limited his entitlements, that may be all he's owed. But remember, I said 80% of the time they're not enforceable. So let's find out how much this person is actually owed. Let's plug that into severancepaycalculator.com again. So he's a senior manager. Worked there for 3 years. I picked an age, let's say mid-50s, and he was offered 3 weeks because his employer believes he has an enforceable termination term. If he doesn't, if it's not enforceable, he's owed 6 months' pay. That's a difference of $53,000. So that's why it's so important to go to severancepaycalculator.com. That's why it's so important to determine whether the contract that you signed is enforceable. Don't assume that it is. Okay, it may not be. Chances are it's not. You have to call me if you lost your job, whether you signed an employment agreement or not, just as important.
Terminationquestions.com, another place you can go to ask your questions. We'll get to one quickly as we're about to wrap for the day. This writes in from terminationquestions.com, says, my brother is an HVAC employee who severely hurt his shoulder outside work. He made a claim early on for LTD, long-term disability, but was denied. He's still not able to return to work a year later, but now his boss is telling him he needs to come back in order to keep his job. You got to come back. Pain or no pain?
Well, let's deal with the LTD first. Just because he's denied by the insurance company doesn't mean that it's right. Insurance companies often are in the business of denying people, getting people off their payroll. Sure. So right off the bat, there's an issue right there. He may be able to deal with the insurance company. We can help him. We do this all the time. If you watch the In Your Corner show, you know about that we can help you deal with the insurance company. Now, beyond that, putting aside the insurance issue, the LTD insurance issue, if your doctor says you cannot work, that's it. It's over. Your employer cannot make you come to work, can't threaten you, can't fire you, can't tell you that you've abandoned your job. You can be off as long as you need to, whether it's a week, a month, a year, or longer. Provide your employer with the doctor's note. Your employer can't do anything to you. If your employer tries, that's a human rights violation. That's a wrongful dismissal. That's a few other things as well. Yeah, right. So the doctor rules the day. Judge and jury when it comes to being sick, being off work. So call us with respect to the insurance company. Anytime your insurance company denies your disability claim or cuts you off, and your employer has to allow you to follow your doctor's advice.
Employmenthourtv.ca is the website. The number is 1-855-821-5900. Till next time, Employment Hour in 30. Thanks for sticking around.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.